Hello, good morning everyone. I hope everyone is fine. So today we'll start with agency. This is going to benefit the first year students the most because it is a very basic topic. And in the first year, I've already completed indemnity, guarantee, bailment, pledge, and therefore I'm starting with agency in this topic. Okay, so let's just start. Chapter 10 and sections 182 to 238 of Indian Contract Act talks about agency. Agency is a very big topic. So in order to learn the provisions in a better way, you can just look into the broad categorization that has been provided under chapter 10. As I have mentioned here also, that appointment and authority of agents has been dealt under sections 182 to 189. Similarly, sub-agents 190 to 195, ratification 196 to 200, and so on. So this way, if you are able to understand, if you are able to learn the broad subheadings and broad provisions, then you will be able to write the answers properly. Okay, so since it is a very big topic, I'll be dealing with it in 2 to 3 videos, and in this video I'll just be dealing with definition, essentials, creation of agency, and duties of agent. Okay, so let's just start with that. Agency is based on the Latin maxim "Q fecit per alium, fecit per se", which means that he who acts through another is deemed in law to do it himself. So if you're going to look into the Indian Contract Act, you'll find that agency has nowhere been defined, but we can always refer to section 182, which provides for agent and principal, and we can draw a definition of agency for ourselves. So as per section 182, an agency can be said as a contract by which an agent is employed by a principal to act on his behalf or to represent him in dealings with the outside world. So let's say when a person is appointed by another to either perform the acts on behalf of such employer or to represent the employer in front of third parties. In that case, the person so appointed can be labeled as agent, and the person who has made the appointment can be labeled as a principal. So you need to understand that representation is an essential element of agency, and that representation must be such which makes the principal liable in front of the third parties, meaning thereby that the third parties must be able to sue the principal for the acts of the agent. This is very important. So representation and authority of agent must be such which alters the legal position of the principal. Now, if you want to understand about the concept of agency more, you can always refer to Justice Ramaswamy in P. Krishna versus Mundela Ganpati case, and you'll find the entire concept of agency explained beautifully in that particular case. Now, another important thing is that not every person who acts for another becomes an agent. For example, a domestic servant who renders personal service to his master, or a person who cultivates the land of another person, or a person who works in a shop, factory, or mine does not automatically becomes an agent here. So what is the differentiating element? Differentiating element is representative character. First thing, that the agent must be able to represent the principal in front of the third parties. Next is derivative authority. Derivative authority here means that the agent must have the authority to act on behalf of the principal, to enter into legal obligations with third persons on behalf of the principal. Such must be the authority of the agent. Next is that he must have the power to affect the legal relation of the principal with the third persons. So these are distinguishing features of an agent, and this basically differentiates an agent from other sorts of people who provide services to another persons. Okay, so moving on to next slide. Okay, so in Gunupati Aluria versus State of Andhra Pradesh, it was held that a wholesale dealer under the Madras Food Grains Procurement Order 1947, is an agent. Now, a wholesale dealer under that particular order was responsible for purchasing and selling of commodities, and he was required to purchase and sell at a price which was fixed by the state. And since that wholesale dealer was operating on behalf of the state, he was labeled as agent of the state. Now, moving on, Section 182 provides for um, agent and principal. So who is an agent? An agent is any person who is employed to do any act for another or to represent another in dealings with the third persons. Now, Section 184 lays down as to who can become an agent. Now, when you're going to refer to 184, you will find out that any person can become an agent. He can be a minor also, he can be unsound mind also, and such kind of differentiation has not been mentioned. It just says that any person as between the principal and third party can become an agent. But we all know that there are certain requirements laid down in the Indian Contract Act, and one of the requirement is that a person must be competent to contract. And when we talk about competency, we talk about age, that the person must have attained the age of majority, and next is that the person must be of sound mind, right? So if you want that agent must be answerable to the principal, then the agent must have attained the age of majority and he must be of sound mind. Now, moving on, who is a principal? The principal is any person for whom the agent acts, or the person whom the agent represents. Or the principal can be anyone who appoints the agent for such act and for such representation. Now, Section 183 provides as to who can employ an agent. So basically it says that who can be a principal. So it says that a principal must have attained the age of majority. Why is it relevant? It is relevant because we have already studied that third person can sue the principal for the act of the agent. Now, in order for this to happen, the principal must have attained the age of majority, because minor's contract is void ab initio as per Mohri Bibi versus Dharmodas Ghosh. You all are aware. So in this case, principal must have attained the age of majority and must be of sound mind in order for the third party to sue the principal for the acts of the agent. Now, next element in forming a contract is that there must be consideration. Now, as far as agency is concerned, if you're going to look into Section 185, it says that consideration is not necessary for creation of agency. Now, what is consideration? Now, in this particular case, agent is generally paid commission for the act that he has done, and therefore agency contract becomes valid, even though as such there is no involvement of consideration as such. Here commission is paid to the agent. Moving on. So next we'll talk about the difference between agent and servant. As we have already studied that agent is authorized to act on behalf of the principal. He has the authority to represent the principal in front of the third party, but such kind of authority does not lie with a servant. Now, next is that principal can direct as to what are the services that the agent is going to provide. It is clearly mentioned in the agency contract itself. So you can just go and Google the format of a contract of agency, and you will find that what are the services of the agent, and for what he has been appointed, and whether he'll be getting any remuneration or not, and when the agency can be revoked. All these things are already mentioned in the contract of agency. In that sense, we can say that principal has the authority to direct what the agent has to do. The principal already decides that for what purposes the agent has been appointed. Next is master controls two things. Master can direct what the servant has to do, and in what manner that particular act has to be done can also be directed by the master. Now, next is that agent is not subject to about direct control and supervision of the principal. Why we are saying this? We are saying this because once the agent has been authorized, once the limit within which the agent has to act, now agent in case of necessity, in case of emergency, can act according to his reasonable skill and diligence also. So in that case, principal is not controlling the agent as such at all the times. Next is, a servant acts under the direct control and supervision of his master and is bound to confirm all reasonable orders given to him in the course of work. Now, in this manner, servant is different from the agent. Next, we have already discussed that agent receives commission while the servant receives salary or wages. Now, an agent can work as an agent for more than one principals at the same time. But when we talk about servant generally works for one master at a given point of time. Next is that agent can enter into contractual obligations with third parties on behalf of the principal, and the principal can be held liable for that, whereas servant cannot create any such kind of legal relations. Now, moving forward. Okay, so if a case comes between the court will basically look into the substance of relation in order to find out that whether a person is an agent or the person is a servant or the person is a bailee and so on. So in that case, in order to determine that whether a person is an agent or not, the court is going to look into the substance of the relation and not at the nomenclature that has been used in the contract as such. Okay, so examples of agent include professional advisors such as stockbrokers, architects, and realtors also. Like if you employ any person for the purposes of selling your house, then in that case, that person will also be your agent. Next is painters or persons who are appointed to prepare a report. Such persons are not labeled as agent. Now there is a difference between agent and bailee also. What is that? First is that agent is a representative with the power to contract on behalf of principal. We have studied repeatedly that agent can enter into contract on behalf of principal with the third parties, but bailee cannot do so. We have studied in bailment that bailee just receives the good for a particular purpose, and then he can either return the good to the bailer or he can dispose of the good as per the directions of the bailer, but he cannot represent the bailer to in front of third parties as such. Next is relation of bailer bailee subsists till the time the bailee holds the good on behalf of the bailer or for some purpose or for any particular use, but it is not necessary in the case of agency relationship. Now, in order to learn more about it, you can always refer to Yuko Bank versus Hemchandra Sarkar case. It is a 1990 case. Okay, moving along. Kinds of agent. First is factor. Factor we have already studied under bailment. So who is a factor? Factor is, he is like a mercantile agent. He is a mercantile agent who is generally entrusted with the possession of the goods of the principal for the purposes of selling them. So what does a factor do? Factor basically receives the goods of the principal and sells the goods of the principal. Okay, so he's a mercantile agent whose ordinary course of business is to dispose of goods of which he is entrusted with the possession or control by the principal. Now, when we talk about broker, broker is also kind of mercantile agent, and he is appointed to negotiate and make contracts for sale or purchase of property on behalf of the principal. But in this case, broker does not necessarily is given the possession of the goods. Next, we talk about Del Credier agent. Who is a Del Credier agent? He is also another type of mercantile agent. Now, in this case, the agent receives some sort of extra commission, and in lieu of some extra commission, he undertakes to be responsible to the principal in case of failure of the third party to perform the contract. So let's say principal has given some extra commission to the agent, and the agent was asked by the principal to sell the goods to some third person. Now if the third party has refused to accept the good, then the principal can sue the agent in this particular case because the agent has taken extra commission, and this commission was to compensate the principal against refusal by the third party to perform the contract. In this case, you can also in this reference you can also refer to Champaram versus Tulsiram case. Okay, so we can say that Del Creditor agent is more like a surety in this case, and he incurs only secondary liability towards principal. Secondary liability, how come? Secondary liability means when the third agent refuses to perform his contract, only then the Del Creditor agent is going to be responsible. So we can see that Del Creditor agent's position is like that of an insurer and partly that of a surety, but he in no case will be liable to the buyer for default of the principal, nor he can be made liable for any dispute between the principal and buyer to the contract or sum due. Next, creation of agency, how agency is created. For this, section 186 to 189 are relevant because these provide that an agency may be express or implied. So when we talk about express contract, we all know that it may be oral or in writing. When a creation of agency is by express contract, when the person either orally says or by entering into a written contract appoints the agent, in that case we can say that agency is express. Next is implied contract. We know in the absence of any oral or contract in writing, if by the conduct or situation or relationship of parties it appears that one person is acting as the agent of another person, that may also be agency, and it will be an agency by implied contract. So when a person is placed, when a person places another in a situation in which that other is understood to represent or to act for him, he becomes an implied agent. इसका example क्या है? Let's say A is owner of a shop and B manages the shop on behalf of A, and in the management of such shop he is in the habit of ordering goods from C, and he orders such goods in the name of A, pays to C from the funds of A, and he does this all these things with the knowledge of A. So in this case, if A is not stopping the person from buying the goods for the purposes of the shop, then in that case we can say that implied agency is existing. Now if there is any dispute regarding payment for the goods, then C can definitely sue A, who is the owner of the shop. Next example of implied agency is agency by holding out or estoppel. Now in this slide we can also refer to the arrangement between wife and husband. So general principle says that wife has implied authority of the husband to buy articles of household necessity. So wife can be an implied agent, but husband cannot be an implied agent of wife. This is the general principle. But if a wife wants to bind her husband for her credit purchases, then there are certain conditions that need to exist. First is that they should be living together. Second is that they must be living in a domestic establishment of their own. And third is that she can only run her husband into debt for necessary items, and husband will not be responsible if husband has been providing reasonable allowance for buying such necessities or for fulfilling the needs of the wife. In that case, husband is not going to be responsible. Husband can also not be made responsible when he had expressly forbidden if he has expressly prohibited the other person from giving credit to his wife. In that case also husband is not going to be responsible. In this slide you can also refer to Girdhari Lal versus W. Crawford case. Okay, so as we have studied that husband is not implied agent of wife, wife has to expressly by an express contract has to appoint the husband as her agent, otherwise there is no implied agency. Now, in Jawaharlal Daima and Company versus Chinta Chitema, it was held that a husband has no implied authority to sell his wife's property. Now, next we talk about agency by ratification. Okay, so section 196 talks about agency by ratification. It says that if a person acts on behalf of another without his knowledge or authority, then the person on whose behalf such act has been done, if ratifies it, then it gives rise to agency by ratification. This type of agency is also known as ex post facto agency. You can also refer to section 196 to 200 in this case. Now you need to understand that there is a difference between implied agency and agency by ratification. What is it? That in implied agency, the person on whose behalf the act was done, he was already aware of it, he had knowledge of it, if you refer the illustration that I told you. But in ratification, the person on whose behalf the act has been done has no knowledge about it, and later on he ratifies the act. Now next is agency of necessity. Now there may be certain extraordinary emergencies in which the agent may be justified in assuming extraordinary powers. Now if the agent acts fairly, then in that case the act of the agent will be binding on the principal. Next. Okay, so next is duties of an agent. So first is duty to execute mandate. An agent is bound to perform the functions with which he has been entrusted by the principal. He has to carry out the functions as per the directions of the principal, and he is bound to perform the services for which he has been appointed by the principal. Next is duty to follow instructions or customs, section 211. So it basically says that an agent has to perform the functions as per the directions of the principal. He cannot act beyond the authority which has been given by the principal, and in case of any in case of absence of such directions, the agent is bound to perform or to act as per the customs that are prevalent in the business in which the agent is engaged. Next is duty of reasonable care and skill, section 212. It says that an agent must conduct the business with as much skill as is required for the purposes of conducting that kind of business. Other than that, he is required to exercise reasonable skill. He is required to act as a man of ordinary prudence would act in his own particular case. Now if the agent has neglected to act as such, or because of his want of skill there has been any direct consequences, then in that case the principal can sue the agent, and agent is bound to compensate the principal. It is necessary to understand that for any indirect or remote consequences because of the neglect or want of skill of agent, the principal cannot sue him. Next is duty to avoid conflict of interest, section 215. It says that if agent acts on his own account without the principal's consent, or without acquainting the principal of all the material particulars, in that case the principal may repudiate the transaction. We can always refer to illustration of section 215, which says that let's say A is the principal and he has appointed B as his agent for the purposes of selling his estate. Now B, rather than following his principal's directions and selling the estate to some third person, he himself purchases the estate of the principal in the name of some other person. Now in this case he has not taken the consent of the principal, and he has not acquainted the principal with all the material circumstances. Now after knowing this, the principal can always cancel such kind of purchase that has been made by B, who is an agent here. Next is duty not to make secret profit. Section 216 talks about it. So it says that if agent acts on his own account in the business of agency without principal's knowledge, then principal may claim the benefit. For example, A is the principal and he has asked B, his agent, to go and purchase certain property at a certain price. Now B tells A that the property is not available for purchase, but he purchases the property for himself. Now in this case, the principal, who is A, can always compel B to sell the property at the price which was originally fixed by the principal, because here the agent has been acting for his own benefit. Now next is duty to remit sums. Section 218 talks about it. It says that agent must pay all the sums to the principal which he has received on principal's account. Next is duty to maintain account. Section 213 talks about it. It says that agent must render proper accounts whenever the principal makes such demand. Next is duty not to delegate, section 190. Obviously, if an agent has undertaken to perform a particular act personally, then in that case In the absence of any ordinary custom of trade or nature of agency is not so, then agent cannot further delegate his functions. He cannot appoint a sub-agent. Okay. So we can say that in agency we talk about three contracts. One is principal and agent, which has already been defined in the section 182. Next would be between agent and third party. Now agent and third party, for this you can refer to section 230, and next contract is between principal and third party. For this you can refer to section 226 of the Indian Contract Act. And as far as other topics are concerned, we are going to refer it in the next video. So thank you, and keep on reading, and it is essential to read the barracks. Okay, thank you so much.